Stop what you're doing. The special counsel just walked in with trembling hands and dropped the bomb on the judge sentencing Trump. Not rumors, not spin. Hard files exposed. Digital trails, handwritten notes, testimony that connects like a fuse. Power collides with truth, and the room goes silent. Prosecutors call it airtight. Defense looks like a meltdown. The judge says it's the most thorough case yet. Outcome-determinative. If this lands, we're staring at the fall of a former president, the collapse of a cover-up, and a courtroom reckoning for democracy itself. What's in the pages that made the room gasp and Trump's strategy crack?
Today, an indictment was unsealed, charging Donald J. Trump with felony violations of our national security laws, as well as participating in a conspiracy to obstruct justice. This indictment was voted by a grand jury of citizens in the Southern District of Florida, and I invite everyone to read it in full to understand the scope and the gravity of the crimes charged. The men and women of the United States intelligence community and our armed forces dedicate their lives to protecting our nation and its people. Our laws that protect national defense information are critical.
Let's start with the simplest truth we have. The rule of law only matters if it binds the powerful. That's the test in front of the country right now. Not a partisan test, not a cable news food fight, but a civics test we all learned in grade school. Do facts still matter? Do both still matter? Does the Constitution still outrank any one man's ambition? If the answer is yes, then the evidence that prosecutors place before a federal judge isn't a political story. It's the story of accountability, finally catching up to power. Here's what we know in plain language. The special counsel's case isn't built on vibes, or punditry, or a guessing game. It rests on three kinds of proof that reinforce one another the way sturdy beams support a roof. Contemporaneous notes, digital records, and insider testimony. Those notes were written at the time by the people being pressured, not years later, through the haze of memory. Those digital records, texts, emails, phone logs, draft statements. Metadata carry timestamps that don't bend to spin, and those witnesses, many of them lifelong conservatives and Trump appointees, describe meetings, phone calls, and directives that align with the paperwork and the pixels. When paper, pixels, and people say the same thing, you're not in the land of speculation. You're standing on bedrock. What do they show? That a sitting president, having lost an election, leaned on every level of the system to cling to power anyway. He was told, repeatedly, by his own lawyers, by senior officials, by courts across the country, that the vice president had no authority to stop the count, that state officials had certified their results, that conspiracy theories about machines and suitcases and secret dumps were false. He heard it, he knew it, and he pressed forward anyway. That is the through line, not confusion, not a good faith disagreement about the rules. Knowledge followed by pressure. The law said no. He said do it anyway. If you've ever been in a meeting where someone tries to make you sign off on something you know is wrong, you understand the dynamic instantly. The power imbalance is obvious. One side has the title, the microphone, the megaphone. The other has an oath and a conscience, and maybe a notebook. Those notebooks matter. You don't take pages of contemporaneous notes about routine politics. You take them when the stakes are constitutional, when the pressure is constant. And when you know, deep down, you may need a record of what really happened.
One set of laws in this country, and they apply to everyone. Very important for me to note that the defendants in this case must be presumed innocent until proven guilty beyond a reasonable doubt in a court of law. To that end, my office will seek a speedy trial in this matter, consistent with the public interest and the rights of the accused.
Now, we need to be honest about how disinformation corrodes public life. For years, many were told to treat facts like a buffet, take what flatters you, leave what contradicts the narrative. The result is a movement that calls every law rigged, every institution corrupt, every neutral referee the enemy if they won't declare your side the winner. That is not democratic dissent. That is a slow, grinding attack on the basic idea that truth exists and that law constrains power. You cannot have a constitutional republic where the law is subordinate to one man's tweets, or where millions are asked to believe that arithmetic stops working when it delivers an inconvenient total. The special counsel's filings cut through that fog. They are boring in the best possible way. Dates, times, quotes, attachments. The legal theory is not exotic. Obstruction of an official proceeding, conspiracy to defraud the United States, schemes to disenfranchise lawful voters. These aren't charges about thoughts or speeches in the abstract. They're about conduct. They're about actions aimed at the bedrock function of our system, counting votes and transferring power peacefully. I know the counterarguments by heart. This criminalizes politics. No, it draws a bright line between politics and crime. Politics is filing lawsuits and losing them. Politics is arguing on TV and hoping voters side with you. Crime is pressuring officials to betray their oath, assembling fake slates to nullify real electors, and trying to block Congress from counting the votes the states lawfully certified. But what about free speech? Free speech protects your right to argue, even to be wrong in public. It does not protect a coordinated scheme to weaponize knowing falsehoods to halt a constitutional process. We protect debate. We don't immunize fraud.
Violations of those laws put our country at risk. Adherence to the rule of law is a bedrock principle of the Department of Justice, and our nation's commitment to the rule of law sets an example for the world.
Let's talk intent, because prosecutors always have to. You don't prove intent by reading minds. You prove it with the unglamorous stuff. Warnings given, memos circulated, advice rejected. Again and again, the record shows advisors saying, "No, Mr. President, that's not lawful. No, that theory doesn't work. No, the Vice President can't do that." And the response was to escalate the pressure, to lean harder, to search for lawyers who would give the desired answer after the election rather than before. That is not a client confused about the law. That is a client shopping for a result after losing in court and at the ballot box. And there's the human cost. We talk about this case as a clash of institutions, but it is also a trail of ordinary people who stood in the way of a lie and paid for it. Election workers who received threats, state officials who refused to find votes and were harassed, a vice president whose family was put at risk because he obeyed the Constitution. When we say rule of law, we're talking about a shield for them. 2, the people who did their duty under extraordinary pressure and needed the rest of us to back them up. There's another argument we have to address: timing. It's too close to an election. In America, proximity to an election has never been a blanket amnesty for crime. If anything, accountability for attempts to sabotage an election is most urgent before the next one. We don't pause the law because the calendar is inconvenient for the defendant. We don't place justice on hold to accommodate a campaign schedule. Equal justice means the courthouse clock does not run on partisan time. Some will say the appeals could take years, that a conviction is never guaranteed, that juries are unpredictable. All true, and none of it is an argument to abandon the case. The rule of law is measured not by certainty of outcome, but by willingness to try, to gather facts, present them in open court, and abide by the verdict. If we only pursue cases that are easy, we're not a nation of laws. We're a nation of excuses. Hard cases are the ones that define us. It's worth zooming out for a second to remember how rare this moment is. For more than 2 centuries, America has managed peaceful transfers of power, even after brutal campaigns, even in times of war, even when rivals despised each other. That tradition is not a relic. It is the miracle at the center of the American experiment. It says, we fight like hell during the election, and then we certify the winner, congratulate the victor, and try again next time. That norm is not weakness, it is strength. It tells citizens that their vote counts, and tells losers that there will be another race rather than a last stand. When a president targets that step, certification, he targets the hinge that lets the whole system swing from one administration to the next without blood or bitterness. You can change policies. You cannot change that hinge without breaking the door. That's why this case feels so fundamental. It asks whether we still possess the civic muscle memory to reject the strong man's temptation, the idea that losing is impossible, and that any loss must therefore be a theft. Democracies do not survive that creed. They decay into rituals that look like elections, but function like coronations. There's a reason judges and prosecutors talk the way they do, measured, careful, a little bloodless. It's not because they don't feel the stakes. It's because the job requires them to resist heat and stick to light. So when you read government lawyers calling this evidence sufficient to obtain and sustain a conviction, that's not a campaign slogan. That's the most cautious branch of public life telling you the proof is not just dramatic. It's durable, built to withstand motions to dismiss, cross-examination, and appeal. We should also say something about those who cooperated. It's easy to paint everyone in Trump's orbit with one brush, but part of the reason this case exists is because many people told the truth when asked under oath. Some served in his administration, some voted for him twice. They still testified. That matters. Accountability isn't vengeance. It's a way to teach future leaders and future staff that your loyalty oath is to the Constitution, not to the man who holds the office for a time. And when the choice comes, because it always comes, between career and country, you side with country and you keep the receipts. What if the verdict goes the other way? What if a jury acquits? Then we will have done what free societies do. We presented evidence, argued the law, and accepted the decision of fellow citizens. That's also the rule of law. But let's not pretend an acquittal would mean the conduct was noble. Juries answer legal questions, not moral ones. The moral answer is already on the public record. Pressure applied to overturn legitimate votes is wrong. Full stop. Whether that wrong clears a high criminal bar is for the jury to say. Whether we broaden our civic immune system so this never happens again is on us. There's one more uncomfortable truth. This case won't heal our politics on its own. Some Americans have been told relentlessly that any accountability for Trump is persecution of them. That is the most toxic lie of all, because it turns a leader's legal jeopardy into a hostage situation. Free him or we'll burn down the house. We have to reject that logic. Being a citizen in a republic means accepting that your tribe doesn't own the courthouse. It means standing up for principles, even when they inconvenience your side. And it means teaching our kids that truth isn't a team sport. So where does this leave us, practically? It leaves us with work, protecting election workers, funding nonpartisan security at counting centers, ensuring that threats are prosecuted swiftly, teaching media literacy in schools so the next wave of weaponized falsehoods lands on a population that can spot the manipulation in real time. And yes, insisting that officials who cross the legal line face consequences, whether they wear a red tie, a blue tie, or no tie at all. Equal justice is not a slogan. It's a set of habits that must be practiced over and over until they become muscle memory again. I don't know how this case ends. I do know how this story should, with us recommitting to the old, unfancy virtues that kept this experiment alive long enough for us to inherit it. Honesty about facts, humility in defeat, courage under pressure, and the quiet pride of doing your job when the whole world tries to make you do otherwise. Those virtues don't trend on social media. They don't fill arenas, but they fill the gap between chaos and community. They are what the notebooks, the emails, and the testimony ultimately point back to. People, imperfect, ordinary people, choosing duty over noise. If the rule of law is real, it is real for former presidents. If truth still matters, it matters when it hurts. If democracy is to mean more than a flag and a song, it must mean that power yields to the people when the counting is done. That is the line. Cross it, and the republic becomes a costume. Keep it, and we keep faith with one another. The special counsel's evidence isn't just a ledger of past wrongs. It's a mirror. It asks us what kind of country we want to be when the next test comes, and it will. My answer is simple, one where no man is the state, where the Constitution is not a prop, and where losing an election is not the end of your voice, just the end of your term. That's the America worth defending. That's the promise worth the paperwork and the patience. And that's why this moment, cold, methodical, legal, feels, in the best sense, patriotic.